The third and final framework decision which I'm going to talk about is one which concerns conflicts of jurisdiction and was enacted in 2009. It's dated the 30th of November 2009, and Member States have to comply with it by the 15th of June 2012 by enacting domestic legislation. The purpose of the framework decision is to try and prevent a person being tried with respect to the same facts in two jurisdictions, so to prevent a violation of the principle of ne bis in idem. It's also trying to ensure there is direct contact between Member States where there may be parallel investigations taking place. It's worth saying that the idea when it was initially floated by the Commission was to have some sort of binding system to ensure that there was a resolution of any disputes between Member States, but that proved to be politically unacceptable, and therefore the current framework decision was arrived at. So the framework decision can really be divided into three stages in terms of how states will deal with the process. The first is the contact stage. So Article 5 says that where a competent authority has reasonable grounds to believe that parallel proceedings are being conducted in another member state, it must contact the competent authority in that other member state to confirm whether or not that's the case. And Article 8 sets out the contents which must be included within this initial contact, so that there can be some sort of proper examination as to whether or not there is a parallel investigation going on. It's essential that this takes place at an early stage because obviously what it's really trying to avoid is the duplication of resources and also the potential for injustice to a person if they're being investigated in parallel without any real coordination. The second stage is the reply, so obviously the contacting authority must reply, and they must do so within the deadline indicated by the contacting authority or without any undue delay if there hasn't been a deadline set, and that's dealt with in Article 6. The response must at least explain whether there are criminal proceedings that are being or have been conducted in respect of some or all of the facts which form part of the request, and if so, it must give the details of the authority which was dealing with those processes and the stage of the proceedings which were reached or which are currently have been reached if the proceedings are ongoing. The third stage is an attempt to try and ensure that the processes are coordinated. So Article 10 deals with this, and where there are parallel proceedings which are taking place, there must be some sort of direct consultation to try and come to a consensus or a solution as to which member state should in fact deal with the criminal proceedings. There may well be some parallel investigation which takes place with coordination to try and gather evidence, but the idea is that there will only be one prosecution for any individual, and that normally co-defendants will be tried together unless there are factors which mitigate against this. There are guidelines which have been published by Eurojust which are aimed at trying to allow prosecutors to have factors to take into account when making a decision as to which jurisdiction is best placed to prosecute. And for example, the United Kingdom prosecution agencies have agreed that they will adopt those guidelines. The difficulty is that sometimes the factors which are set out in the guidelines point different ways. So for example, it may be that all of the conduct in a case has taken place in one member state, but in fact all of the loss has taken place in a different member state. So those two factors will be pointing in diametrically opposite directions, and it will be more difficult for the guidelines to provide an obvious answer as to which state should in fact prosecute. So there should be this attempt to reach consensus, but if it's not possible to reach consensus, then Article 12 mandates that the matter has to be referred to Eurojust. And Eurojust will try to bring the parties together and try and reach some sort of consensus by mediating. But what isn't possible is for Eurojust's decision to be binding. And as I said, this has been the original proposal of the Commission, but Member States simply weren't willing to agree that Eurojust be granted this power. So instead, there really has to be an attempt by Eurojust to make the parties see sense and to try and give their own interpretation of the way in which their guidelines should lead to a result in terms of determining a country to prosecute. The communications between the authorities must produce a written record so that there is some sort of trail as to what has happened, and that's something which obviously Eurojust can use when and if it needs to be brought in order to try and reach some form of consensus. So those are three framework decisions. The first is the cornerstone of the mutual recognition process, and it's the forerunner of all of the other framework decisions which deal with mutual recognition. The second makes amendments to other framework decisions to try and ensure some sort of consistency in terms of dealing with trials and absence. And the third is looking at what's going to become an increasingly frequent issue about the forum and which country should prosecute where more than one country has the jurisdiction to prosecute.